a chi è qui presente in sala e a chi si è collegato a distanza. Iniziamo questo evento con i saluti istituzionali che sono portati dal professor Alessio Zaccaria, presidente dell'Accademia Internazionale del Derecho de Sucesiones, che in questa veste anche modererà il nostro evento. Prego, professore.
Grazie professor Tescaro, grazie dell'invito. Sono sempre particolarmente lieto di essere qua. Mi piace Vicenza, mi piace questa università, ho avuto tante volte occasione di ritrovarmi in questa sede per eventi sempre interessanti. Devo dire che non avrei mai pensato, quando ho accettato l'invito, di aprire questo pomeriggio con quanto ora sto per dirvi. Pensavo, e questo rimane fermo, di manifestare la mia soddisfazione nella veste di presidente di questa Accademia del diritto successorio, un'accademia che ha basi in America Latina, particolarmente in Argentina, in Europa, nei paesi europei. Ecco, dicevo, volevo manifestare, manifesto sicuramente il mio piacere e la mia soddisfazione per questo allargamento anche dal punto di vista della nostra Accademia verso diritti, ordinamenti giuridici al di fuori di quelli che abbiamo sino ad oggi affrontato, in particolare oggi un allargamento nei confronti del diritto russo. Quanto sta accadendo in questi giorni, peraltro, mi obbliga in un certo senso a spendere due parole in più su un fronte diverso, che non c'entra molto con il diritto, ma c'entra con la vita di tutti noi, indirettamente anche con gli ordinamenti giuridici, perché no? Dirò solo due cose molto brevemente. Vi racconterò una cosa che mi è capitata proprio questa mattina a colazione. Io ho due figli, una figlia di 13 anni e un bambino di 9 anni. Mio figlio, come fanno i bambini di questa età, passa regolarmente il suo tempo, non proprio l'intera giornata, ma una certa quantità del suo tempo, giocando in rete con quei giochi, quelle applicazioni che consentono appunto di frequentare altri amici, i suoi compagni di scuola, ma non solo, perché ogni tanto si collega a qualcun altro, allargano il gruppo e si raccontano le cose. E questa mattina a colazione gli ho chiesto, come facciamo ogni tanto, un po' per tenere d'occhio la situazione, un bambino di 9 anni, in fin dei conti, giocando con Nintendo e queste cose, i pericoli sono modesti, non è Facebook, non sono questi social che sono un attimino, anzi senza un attimino sono senz'altro più pericolosi. Ma insomma cerchiamo in ogni modo di controllare le sue attività. E questa mattina gli ho chiesto, dico, hai incontrato qualcuno di nuovo in rete con chi hai giocato ieri sera? Dice, ah papà, cosa c'è? Ieri sera ho giocato con uno che ha fatto la guerra. Come con uno che ha fatto la guerra? Hai 9 anni, giochi con Fortnite? Sì, papà, ho giocato con uno che ha fatto la guerra. Dico, ma quando? Perché il primo pensiero è questo è un adulto che si è infilato lì dentro, che ha fatto la guerra, non so quando, dove, perché. Dice, guarda, la guerra l'ha fatta la settimana scorsa. Dico, no, fermo. Dico, la guerra l'ha fatta la settimana scorsa. Dico, ma cosa ti ha raccontato? Ah, dice papà, è un ragazzo che è venuto dall'Ucraina, che adesso si trova a Milano perché aveva conoscenti, parenti, parla l'italiano perché i genitori sono stati in Italia e lo hanno educato a parlare la lingua italiana. Beh, dico, cosa ti ha raccontato? Ah, dice papà, guarda, serissimo naturalmente, cioè guarda, mi ha raccontato che lui là la notte si svegliava, vedeva il cielo rosso sentiva delle enormi esplosioni, e poi mi ha raccontato che ha fatto un viaggio tanto lungo che non finiva più, che si è fermato in tanti posti, finché finalmente è arrivato a Milano. Era molto impressionato, perché un discorso è giocare alla guerra con i videogiochi, un discorso è sentirsela raccontare da chi l'ha vissuta. Cosa devo dirgli? Cosa gli ho detto? Cosa potevo dirgli? Figlio mio, io sono stato molto fortunato, perché io non ho mai visto la guerra in casa. La vedo in televisione tutti i giorni, ma è un'altra cosa, anche rispetto a un'esperienza diretta, sia pure superficiale. Ne ho sentito parlare, poco per la verità, da mio papà, che poi è tuo nonno Gabriele, poco per la verità perché non amava parlarne. Ne ho sentito parlare da mio papà, il quale, delle sue esperienze, campo di concentramento, guerra partigiana, non amava parlare. Le voleva non lasciare dietro le spalle, ma diciamo voleva proteggermi probabilmente. Mi ha raccontato qualcosa, ma molto poco. E allora l'unica cosa che si può dire a questo bambino è: figlio mio, spero che tu sia fortunato quanto me, spero che anche tu nella tua vita non veda mai la guerra dentro casa, spero che tu ne senta solo parlare, e già questa testimonianza che hai ricevuto per caso, vedi quanto ti ha impressionato e quanto male ti ha fatto, quanto preziose siano la pace e la libertà che il mio babbo e il tuo nonno ci ha lasciato. Mio babbo e il tuo nonno ha fatto in modo di lasciarci a rischio della vita, e c'è anche mancato poco che la vita non la perdesse, almeno in un paio di occasioni. Auguri, figlio mio, speriamo che la tua esperienza di guerra rimanga limitata a questa testimonianza in cui ti sei imbattuto. Era serio questo bambino, cioè, non l'avevo mai visto così serio, ha avuto un'impressione forte, veramente forte, di questo. Speriamo tutti che riusciamo a conservare questa pace e libertà che per 80 anni ci ha accompagnato, e speriamo continui ad accompagnarci nonostante la follia dell'essere umano che scatena queste situazioni impensabili solo fino a 15-20 giorni fa, assolutamente impensabili. Nessuno avrebbe mai pensato, dopo 80 anni, di ritrovarsi in una situazione di questo genere. Ma non vi voglio tediare con queste cose, sono riflessioni che io mi sentivo di comunicarvi a voce alta, perché stiamo tutti vivendo queste giornate, credo, in maniera abbastanza faticosa. Torniamo alle nostre cose, torniamo a questo incontro sull'ordinamento giuridico russo delle successioni, incontro che sarà certamente interessante perché andremo a confrontarci con un ordinamento giuridico che, quantomeno per storia, è abbastanza lontano dagli ordinamenti giuridici nostri continentali. È una bella occasione questa di avere con noi una docente che è in grado di raccontarcelo, oltretutto in lingua italiana, che effettivamente non è cosa semplice, è cosa da apprezzare, per poter ascoltare una... Lo parlo con qualche italiano ogni tanto? No, solo in inglese. E vabbè, ci accontenteremo dell'inglese. Ce lo racconterà in lingua inglese e quindi ci accontenteremo di ascoltarla in lingua inglese. È una lingua che io non amo tanto, come sa il professor Tescaro. Ahimè, la devo parlare e comprendere per ragioni di lavori professionali fosse stato per me, mi sarei fermato al tedesco. Ma comunque, vabbè, insomma, ci accontenteremo della lingua inglese e ascolteremo dunque queste sue riflessioni e questa illustrazione dell'ordinamento giuridico russo. Rinnovando, per quanto mi riguarda, nella veste di presidente dell'Accademia Internazionale di Diritto delle Successioni, la soddisfazione per questo allargamento di orizzonte che certamente ci potrà arricchire sotto tanti profili. Cedo la parola alla professoressa, professor Tescano, sì?
Se mi è consentito dire due parole, volevo semplicemente ringraziare intanto di nuovo il professor Zaccaria perché ci ha concesso il patrocinio dell'Accademia da lui presieduta e poi volevo rivolgere un ringraziamento molto sentito alla professoressa Buniatova che è stata qui a Verona e anche a Vicenza ormai un mese, quasi un mese, si avvicina ormai il tempo della sua ripartenza, è stata una collaborazione molto proficua e io spero e credo che continuerà questa collaborazione e ringrazio sentitamente anche la professoressa Marini che viene dall'Università di Roma Tor Vergata, dove c'è un centro di studi giuridici latinoamericani che è un ente prestigioso, ben noto a livello internazionale, che si occupa di storia del diritto, diritto romano e comparazione, e questo ci sarà spiegato poi meglio da lei, e nell'ambito di questo centro, diretto dal professor Riccardo Cardilli, è stato creato di recente anche un osservatorio su persona e famiglia, di cui la professoressa Marini è responsabile, quindi credo che sarà prezioso il suo intervento per commentare e approfondire dal punto di vista storico e comparatistico questa introduzione al diritto russo. E per quanto riguarda invece i contenuti della relazione, io ho avuto modo di esaminare prima il sommario e mi sono fatto già qualche impressione, mi riserverei se ci sarà modo di intervenire poi nel dibattito. Ecco, la prima impressione è di un sistema che quello russo, che nella sua evoluzione storica presenta differenze anche radicali rispetto al nostro. Si parla addirittura di abolizione dell'eredità, forse vedremo poi in quali termini, ma abolizione dell'eredità e poi di un avvicinamento al modello occidentale, per quanto il modello occidentale sia anche quello dell'Europa continentale sia molto variegato al suo interno, perché basti pensare alla differenza tra il diritto tedesco e il diritto italiano in tema per esempio di patti successori o di testamento congiuntivo, e sono anche questi argomenti presenti nel sommario, ma non mi dilungherei e quindi ringraziando ancora sentitamente la professoressa Buniatova per la sua presenza a Verona. È stato un viaggio non facile che ha dovuto affrontare e che affronterà anche per ritornare poi in Russia e sono veramente lieto di poterla ascoltare. Quindi grazie ancora.
Grazie. Buongiorno a tutti, vorrei ringraziare il professore Zaccaria e il professore Tescaro per l'introduzione, anche il professoressa Marini per venire, ma io...
Forse deve parlare un po' più forte.
Ok, sì. Ok, ma io parlerò sempre inglese perché penso che sarebbe difficile per me parlare di tutto questo in italiano. So switching to English, I'm going to speak about the developments of inheritance law in Russia and about the current state of succession law in Russia. And I will start with a brief overview of legislation governing inheritance issues after the revolution of 1917, as it is very important to understand certain aspects of current legislation and its development trends, because without it, it might be a little bit difficult to understand those current trends that are present in inheritance law today. And afterwards, I will speak about current legislation, about the provisions of the current civil code of 2001, and to be more precise, 2003. We speak about the third part of it, which covers inheritance issues. And I will finish by speaking about the reform of succession law, which was carried in 2018-2019, and the new legal provisions, which will enter into force in 2022. As for the state of succession law before the revolution of 1917, I'm not going to touch upon that for the purposes of this lecture, as it might be an issue of a separate discussion. The only thing that I would like to point out, just to put you into the picture about the development of succession law before the revolution, is that it developed rather slowly and inconsistently sometimes. And if we reflect on the reasons of that, we might suggest that the country before the revolution was mostly agricultural and was not going through massive industrialization like Western countries did at the time. Consequently, before the revolution, just a minor part of the population accumulated capital, and its turnover was slow. Therefore, succession issues were not urgent, so the legislation was not developing in a consistent manner. And generally, succession law in Russia was relevant, before the revolution, was relevant to the upper class, which constituted the social minority. At the same time, the majority of the population could not even enjoy the opportunities provided by law. So I will start by speaking about an important milestone in the history of Russia, which was the revolution of 1917, and which influenced and dramatically changed all spheres of life, including law and, well, inheritance law in particular. The revolution became, a major milestone in the development of law, and as I have already said, in the development of inheritance law, and it was a huge milestone, also due to the fact that the revolution completely abolished the notion of inheritance in Russia. And the Soviets rejected the idea of private ownership. Therefore, the government introduced a decree on abolition of inheritance in 1918. According to the decree, the major part of the estate went to the state, Russian Socialistic Soviet Federative Republic. As for the heirs, they received the share of the estate not exceeding a certain sum of money, which was equal to 10,000 rubles. the portion, that portion of the estate which was subject to inheritance and which was subject to transfer to the heirs included farms, household furniture, and tools of personal labor. The decree singled out the surviving spouse, disabled relatives in the direct ascending and descending lines, and full and half siblings as potential heirs. Thus, if they were those persons that I enumerated, if they were in need or disabled, that is, they were incapable of working, they were entitled to receive maintenance. And if we reflect on the nature of this decree on the abolition of inheritance, I suppose we can deduce that we can hardly speak about complete abolition of inheritance. Firstly, a certain degree of social security was still retained. That is, disabled relatives of the deceased were entitled to receive certain allowance. Secondly, the heirs had the right to dispose of the property, the value of which did not exceed, as I said, the certain sum, which was 10,000 rubles. And this could be interpreted as a way to transfer property. Moreover, it appears, well, more or less obvious, that in order for the state to appropriate property, it should have known exactly what particular assets the deceased owned. However, this was impossible to know because there was no legal requirement to make an inventory of the deceased person's assets. And in other words, we might suggest that the decree on, despite its name, on the abolition of inheritance, established sort of a framework for further development of Soviet succession law. It also, the decree also revolutionized the legislation by authorizing the surviving spouse to inherit equally with the decedent's children. Another substantially new provision granted equal inheritance rights to men and women. Another milestone, and I'm going just to provide a very brief overview of those major periods of Russian history of succession law after the revolution. So I'm switching to another important milestone, which is the so-called Golden Age, the 1920s, which was the age of new economic policy. That was the time when the Bolshevik regime still tolerated kind of pluralism in a number of spheres. And yes, as I said, it was considered to be a golden age. That is in 1922, that very period, a new civil code was promulgated. And as opposed to the 1918 decree, the civil code re-established traditional principles of inheritance. That is, it re-established testamentary and
intested succession rules. However, the circle of heirs, the circle of beneficiaries, was limited to the next of kin, so to the closest relatives, and to testators, to the decedent's dependents. Therefore, testamentary dispositions could only have been made in favor of heirs, not third persons. Thus, an old tradition, which was present in Russian succession law even before the revolution of 1917, that is the rule to retain the estate within family, was not reestablished, was reinstated. Once again, this very long-standing principle was reaffirmed, and a will remained a means to redistribute property among family and among family members. So, notably, if the testator didn't have heirs, so if there were no heirs, the property deemed to be escheated, so it went to the state. As for the form of a will, it had to be made in writing and signed by the testator or a person authorized to sign on the testator's behalf if if the testator was incapable of signing. Afterwards, the will was subject to certification by notary and had to be deposited in the notary's office. Importantly, the Civil Code of 1922 was amended in 1926 with regard to adopters and adoptees, who from then on, from 1926, were deemed to be relatives. And consequently, adoptees obtained the right to inherit after the adopter or after their adopter or adopters died. Later, in 1928, the All Russian Central Executive Committee and the Council of People's Commissars issued an order introducing a compulsory share, so a forced share in inheritance. And according to that order, the minors, minor heirs, so heirs under the age of 18, received no less than 3 quarters of the share they were entitled to receive, to inherit, notwithstanding the contents of a will. Just to point out, today the forced share is half. Half of the estate that an heir would have inherited if there was no will. Gradually, the development of socialism led to the abolition of private property, which, among other issues, signified that new rules were needed to govern succession law. Rules of succession had to be brought in line with social and economic changes which were taking place in country and in society. And however, the Great Patriotic War, so the Second World War, delayed the reform, and consequently, the rules amending succession law were only introduced in 1945. Oh, I'm sorry, I missed I missed the slide of the Civil Code of 1922, and I have already told and spoken about the main provisions of the code, and here they are. The next milestone, is the 1945 decree on devisees and heirs. And so the rules, all the rules that I mentioned above, so the rules of the Civil Code of 1922 with the amendments of 1926 and 1928, they remained in force until 1945, so until the decree on devisees and heirs was introduced. Here it is. And this decree expanded the circle of beneficiaries, it expanded the circle of legal heirs, and for the first time in the history of Russian inheritance law, introduced 3 orders of succession. That is, children, including, as I have already told, adopted children, so adoptees, surviving spouse, as well as the decedent's disabled dependents. That was the first order. The second order consisted of the decedent's parents, regardless of whether or not they had been his dependents. And the third order included decedent's siblings. Moreover, the decree expanded also not only the circle of legal heirs, but also expanded the decedent, the testator's testamentary freedom. However, testamentary dispositions could have been made in favor of a third party unless there were no heirs. So if there were heirs, the rule was just the same, that the estate was or had to be retained in a family. However, if there were no legal heirs, then not necessarily the estate had to go to the state, so become escheated. The testator obtained the right to transfer this property to third persons. As for the form of a will, historical circumstances at the time demanded the introduction of a simplified form. So due to historical circumstances and events, so a simplified form which was suitable for military personnel. Wills attested by military commanders became equivalent to wills certified by a notary. Another important document in the history of succession law in Russia was the document entitled Fundamental Principles of Civil Legislation of the USSR and Union Republics. So succession law rules adopted in 1945 in the decree that I have already spoken about. They remained in force up until the introduction of this very document in 1961. And prior to its promulgation, succession issues used to be interpreted and construed by the USSR Supreme Court Plenum and governed by regulations enacted by ministries. The 1961 fundamental principles envisaged fundamentally new provisions with regard to succession law. The new law set out both testamentary and intestate succession provisions. To point out, and this is important because I'm going to speak about it later once again, to point out the articles governing intestate succession issues in this document in fundamental principles came before those dealing with testamentary succession issues. And evidently, this highlighted the importance of intestate succession over testamentary succession, so over a will. With regard to testamentary succession issues, one of the articles of the fundamental principles, namely Article 119, provided that the testator was authorized to make a will in favor of any person, state or social organization. And that was something new, which was introduced in this document. The provision, this provision, for the first time in the history of Russian inheritance law, this provision changed the principle of retaining the wealth within the family of the decedent, of the testator. And that pattern of retaining the estate within a family existed throughout the whole history of Russian succession law, both before and after the revolution, and was changed only in 1961. This is why this document, Fundamental Principles of Civil Legislation, is very notable from this point of view as well. This law, the Fundamental Principles of 1961, retained the provision regarding the forced share, compulsory share, which constituted now, and that was changed a little bit, constituted in 1961, according to the provisions of this document, 2/3 of the share that minor or disabled children, a disabled spouse, or parents, as well as the decedent's dependents, would have received in the absence of a will. Another document, another important milestone was the Civil Code of 1964. So the year of 1964 was marked by the adoption of a new Civil Code. The code once again underscored the importance of succession law, yet the rules governing succession issues were profoundly different from those rules, from those existing in the majority of European countries at the time. Indeed, property subject to ownership was still limited at those times. So the types of inheritable property were also limited. As for the will and the type of will and the nature of a will, it was regarded as a special instrument, a special tool, which could be drafted on rare occasions. In the absence of a will, estate was transferable to the decedent's next of kin, so to the decedent's close relatives. All those rules were designated to underline the victory of communism and vanishing of private property. Thus, succession law was supposed to wither away as a so-called bourgeois remnant. The 1964 code followed the general pattern of dividing the law of succession into testamentary and intestate succession. So correspondingly, intestate succession took place if no will was made. To point out, like all the previous documents that I mentioned, the code underlined and highlighted the priority of intestate succession over testamentary succession, also by placing the provisions dealing with intestate succession before the provisions governing testamentary succession. As I have already told, this is something important, as I think, and I'm going to return to that, speaking about the new code of 2001 a little bit later. The code of 1964 vested every individual with the right to leave property to any person, the state or social institutions. So this rule was reinstated. And the code also retained the compulsory forced share rule. The testator obtained the right to disinherit all or one of their heirs. Moreover, the testator had the right to change or cancel the will at any time, drafting a new will or submitting a written notice to with the notary's office. The will had to be, as for the form of a will, as it used to be before, it had to be made in writing, signed by the testator and certified by a notary. Moreover, the code defined the time of the opening of inheritance, as well as the notion of a person not authorized to inherit. That is the one who, behaved wrongfully with regards or towards the testator, failed to fulfill obligations prescribed by law, and had been deprived of rights, of parental rights. Secondly, this new law introduced the notion of accretion of hereditary portions. That is, in case a beneficiary under a will or an heir did not accept the inheritance, or if a testator had disinherited, then the corresponding person's portion was transferred to other heirs in equal shares. Another, let's say, third new provision introduced by the Civil Code of 1964 was that the code entitled the testator to substitute an heir if another heir had died before inheritance opened, or refused from inheritance. Furthermore, the testator obtained the right to burden, to impose a burden on a beneficiary under the will to perform certain obligations in favor of third parties. For example, to grant life interest in the hereditary estate. Testamentary succession, however, was mostly disregarded in the 1964 code, and the majority of rules dealt with intestate succession matters. Indeed, what I was just speaking about, have been speaking about, were rules governing intestate succession. So the code, in terms of intestate succession, introduced 4 orders of succession, as opposed to previously existing rules which provided and set out 3 orders. The Code of 1964 introduced 4 orders of succession. So, and heirs in each order were supposed to inherit property in equal shares, regardless of the order and inheritable portion of the estate. Heirs living together with the testator for a period no less than a year before the testator's death were entitled to receive his household furnishings. Another milestone, the fundamental principles of civil legislation of 1991. The end of the 1980s, was marked by the trend to political, economic, and social reforms aimed at switching to market economy and establishing the rule of law. Civil legislation, consequently, had to be brought in line with this new circumstances and had to be amended accordingly to new realities and to new social and economic and political circumstances. And so the new civil code entered into force in 1991. It was named Fundamental Principles, well, as you can see, of Civil Legislation of the USSR and the Union Republics. Notably, and I will point out this once again, that provisions governing intestate succession preceded, once again, those governing testamentary succession. So the role of succession without a will was once again highlighted. One of the articles, namely Article 155 of the Code, said that the testator was authorized to transfer property through will to any persons, regardless of whether they were heirs, so whether they were relatives, next of kin or not, as well as had the right to deprive of inheritance. However, compulsory share, so forced share, was reserved to testators' minor and disabled heirs in the first order of inheritance. The amount of the compulsory share, as well as the circle of heirs in each order, was determined by legislation of the republics. As for the form of a will, the code envisaged only the will attested by notary, unless another form was provided by a statute of union republics. So the article, as I said, Article 155, entitled "The Union Republics" to introduce additional types of wills, a provision which might be considered revolutionary for the Soviet succession law. Obviously, the fundamental principles did not adequately respond to new circumstances, especially after the collapse of the Soviet Union, and new social and economic conditions required urgent reforms in all spheres of life, including and law, including succession law. And so, with the development of market economy, business, entrepreneurship, property rights, the range of objects that could be inherited expanded. And therefore, succession law issues became very urgent. So finally, in the whole history of Russian succession law, they became indeed very urgent. Therefore, in 2001, Russian legislators adopted a new civil code, the part which came into force in 2002, and this part of the civil code, part 3 of the civil code, dealt with succession rules. And this document, this civil code of 2001, is a landmark in the development of, can be considered a landmark in the development of Russian succession law. In that, and this is what I have wanted to say when I highlighted every time that the rules governing inheritance, intestate succession preceded the rules governing testamentary succession. This was because I was going to say that the Code of 2001 became a landmark document in that for the first time in the history of Russian succession law, the Civil Code of 2001 placed regulations and provisions governing testamentary succession before the provisions governing intestate succession, thus finally highlighting the importance of testamentary succession over intestate succession. So this new civil code changed the role of a will and made it the primary grounds for succession. Moreover, as opposed to previous code, let's say as opposed to the code of 1964, which contained only 11 articles on testamentary succession, the current civil code contains more than 20. As for the most significant provisions of the new code regarding inheritance law, first and foremost, the new code expanded the circle of heirs up to the 7 classes or orders. I tried to make this, scheme. However, well, I believe you can figure it out and see what I tried to make here. Yeah, 7 introduced for the first time in the history of Russian inheritance law, introduced 7 orders of heirs. Moreover, it introduced 5 types of will, namely wills attested by a notary, certified by a notary, closed wills, wills qualifying as wills attested by a notary, wills under extraordinary circumstances or emergency wills, and testamentary dispositions of funds in banks, so funds and banking accounts. The most popular one, the most popular will, is always a will certified by a notary. It is popular mainly because its drafting rules and procedure are clear and obvious. It is drafted under the guidance of a notary and subsequently registered by the notary. Notarial wills can be either handwritten or typed. A witness may be present if the testator so wishes. Following the death of the testator, a notary opens the will in front of 2 witnesses. And likewise, in places where there is no notary, the attestation of a will might be, or even must be, performed by an official or executive authorities. And abroad, if a person is somewhere abroad and willing to draft and to make a will, then by a consular institution of the Russian Federation, and those wills are the ones qualifying as wills certified by a notary. Another type of will, which is rather controversial, I would say, is a closed will, which is aimed at keeping the contents of a will secret, even from the notary. And it has a different name in different jurisdictions: closed will, mystic will, etc. In Russia, it is well translated into English as a closed will. So according to the Russian Civil Code, a closed will must be handwritten and signed by the testator. This is the statutory requirement for the validity of a closed will. Therefore, it is impossible, as we can deduce, it is impossible to use a computer or a, let's say, typewriter to draft a closed will. It can only be written by hand. Upon completing the text, the testator puts the will in an envelope and seals the envelope. Afterwards, the testator passes this envelope to the notary in presence of 2 witnesses who sign the envelope. The notary then takes this envelope and inserts it in another envelope and seals it. And Russian notarial practice defines this envelope, the second envelope, as a storage envelope. A significant aspect is that the notary informs the testator about the forced share and about the forced heir rights and handwriting requirements only after receiving the storage envelope. At this stage, however, it is obviously too late for the testator to get to know this information because the will is already written and inside the envelope. If we think about advantages of this closed will, we might say that certainly it excludes a chance or a possibility of forgery. So the testator can draft it outside the notary's office, and this really can be a sensible way to express testator's intentions, maybe, as I might guess, in a rural area. The notary who attests an ordinary will can be someone's, say, neighbor or relative. Therefore, the testator cannot make sure that the contents of a will be kept secret. Another reason to resort to a closed will might be the testator's high social status. Certainly, neither the notary nor notary's employees can get to know and therefore disclose the contents of that will. However, as I think, the drawbacks of this type of a will are more significant than the advantages. So, firstly, it is impossible to check the contents of the will while the testator may have failed to take into account certain rules, for example, compulsory heir rights, let's say, or some other rules regarding the drafting of this type of will. And this may be grounds, so consequently, this may be grounds to invalidate a will. And as a consequence, the estate would pass to legal heirs, not to the beneficiaries under a will. What I would like to mention here is that some legal systems regulating a closed will prescribe a conversion of the will form, considering the already highlighted danger of the invalidity of the testament, of testator's testamentary dispositions, due to the lack of control of the contents of a closed will by the notary. For instance, as I know, French and Italian laws provide for that. If the last will does not meet the requirements for a secret will, it will be valid as a holographic will. If the requisites for its validity are fulfilled, of course. However, the Russian legislator did not accept such a solution, or let's say has not accepted such a solution, although explicitly requests that the closed will must be handwritten and signed by the testator. Going back to the drawbacks of the closed will, my second point is that the rules governing the closed will limit the testator's freedom to some extent. For example, an illiterate person is unable to make a closed will, or let's say a person who is unable to sign their will owing to certain circumstances, and thus this person is also unable to make a closed will. Thirdly, the will, well, speaking about another drawback, the will stored in an envelope, in the storage envelope, may turn out to be drafted in a foreign language. This is also a possibility. In a foreign language, for example, for instance, unknown to the notary. And the law, nonetheless, requires an immediate announcement of the contents of a will upon opening the storage envelope, upon opening the envelope containing the will. Consequently, the notary opens the envelope, finds this will written in a foreign language, and what happens is that the notary is unable to finish the procedure, that is to read out the text. And well, among other ideas that we can think about and come up with in order to amend the provisions regulating closed will might be issuance of templates containing guidelines on how to draft a closed will, listing all of the rules in order to avoid invalidation of a will. In order also, another idea, in order to keep up with modern trends in succession law and to advance the existing legislation, Russian legislator could allow video recorded wills. This could be a good solution to make a closed will available to testators who are illiterate, let's say, or testators who, well, with certain physical, challenges, who are unable to sign, unable to write. Interestingly, the closed will was introduced into Russian succession law in 2001. And thus, we can deduce that it is considered to be a modern type of testamentary disposition, okay, if it was introduced in 2001. However, according to the research I conducted regarding this type of a will in foreign jurisdictions, it seems that by contrast in other countries, in foreign jurisdictions, this type of will is kind of obsolete and regarded as outdated. And consequently, it's according to certain statistics, is rarely used by a testator. Another peculiar type of a will introduced by the Civil Code of 2001 is a will under extraordinary circumstances, or emergency will. It's also a little bit peculiar. These are circumstances, extraordinary circumstances. This is a literal translation from Russian into English, this testament or will made under extraordinary circumstances. These are circumstances where the testator is in a life-threatening situation and thus may not survive to make a will through other regular means. Wills of this kind are handwritten and signed in front of two witnesses. If the testator survives the life-threatening situation, the will becomes invalid within a month when the situation ends. However, the law does not clarify, and this is very important, the law does not clarify what a life-threatening situation is and what its prerequisites are. So what kind of a situation might be considered life-threatening? besides the requirement to find where and how to write, for instance, where to find a piece of paper and a pen under life-threatening circumstances. It also might be a complicated issue. Let alone to find witnesses in this life-threatening situation, 2 witnesses in a life-threatening situation. And it seems to be very complicated. Moreover, I can suppose it seems to be hardly feasible, hardly possible. All of this circumstances make emergency wills unpopular among population, which is which is even such the population as such is not active in disposing of their property through a will, and let alone using this very form, which is really complicated, because, as I said, firstly, we don't know what extraordinary circumstances are, and besides, if we really feel that we are under extraordinary circumstances, how can we find 2 witnesses? How can we find where to write and how to write, and etc. So this is why this type of a will seems not to function well. Indeed, it is important to mention that due to historical reasons that I mentioned before, due to the historical reasons that I have been speaking about after the revolution of 1917, and also the circumstances before the revolution of 1917, wills were not, and maybe now, a little bit more, but still cannot be considered an extremely popular way of property disposition. And according to the statistics, 20% of all estates pass by testamentary, through testamentary succession. However, and this is also an important issue to point out, the first half of 2021 saw the rise in number of wills, and it constituted, in figures, 263,000 in 2021, compared to 215,000, a little bit more, in the first half of the 2020. So there is a rise. There has been a rise, and this rise might be explained by the COVID-19 pandemic. Another issue which I would like to speak about is a succession law reform. In 2019, Russian legislators introduced new arrangements which are aimed at expanding property disposition rights for Russian citizens. The first new mechanism that entered into force on the 1st of June 2019 is inheritance contract. However, as we know, this method of property disposition has long been known and widely used in many countries. Among many countries are Germany, China, France, okay, the Czech Republic, etc. And after the collapse of the Soviet Union, many of its former republics adopted the rules of European legislation, including those dealing with inheritance contracts. For instance, Latvia, Estonia, Ukraine. To point out, that was also not the first attempt for the Russian legislator to adopt inheritance contracts. In June 2013, the similar proposal was submitted to the State Duma, but well, it was not approved. And then another step was in 2015, when the State Duma received another draft bill proposing to amend, among others, rules governing successions, and in particular, introducing inheritance contracts. However, was not adopted, and that draft bill was aimed at providing more opportunities for the testator to dispose of their property. And that draft bill also contained, apart from inheritance contract, contained provisions regarding introduction of mutual wills and so yeah, inheritance contract. But after review process, the Presidential Council on Codification and Enhancement of Civil Legislation disapproved of that reform, and debates followed among legal scholars and legislators. And finally, in 2019, the new bill introducing changes and modifications to the Russian inheritance law provisions entered into force. For Russian law, inheritance contract is absolutely new provision. It's a new contractual agreement entered into by and between a testator and their heirs. However, so far, we haven't had enough court practice which could make help conclusions regarding its efficiency. I would like to single out certain challenges and speak about certain challenges of implementation of inheritance contract in Russia. So firstly, after the amendments were made, the Civil Code now provides three grounds of succession: so will, inheritance contract, and law. So intestate succession provisions. So the inheritance contract now comes second after the will. However, and it's also important to highlight that there is no separate chapter in the Civil Code governing inheritance contracts. So there are certain rules governing wills, governing intestate succession. However, there is no a different chapter governing inheritance contract. Instead, they are set out in chapter 62, governing testamentary succession. And in this case, well, questions arise as to the nature of inheritance contract. That is it a type of a will? If not, what is the correlation between a will and an inheritance contract, which is given priority when the testator has drafted, and if the testator has drafted both? The Civil Code does not provide any answers as to the legal force of those two documents, of a will and of inheritance contract. The answers can only be found in court practice, as we might guess, but court practice has been insufficient so far. Okay, insufficient, if not to say non-existent. Another issue, the second point I would like to make is regarding similarities and differences between a will and an inheritance contract. Speaking of the differences, as for testamentary arrangements, a testator can cancel his will at any point of time and does not have to inform anyone about this fact. The Civil Code provides a unilateral refusal by the testator, certified by a notary who must notify other parties. However, as opposed to a will, in case of a inheritance contract, the testator must pay damages. Speaking of the similarities, the issue is the following. Under testamentary succession rules, the estate must be accepted within 6 months after opening of the inheritance. As for the inheritance contract, it enters into force immediately upon the testator's death, and the estate passes directly to the beneficiary. Therefore, in practice, it can easily occur that an inheritance contract can be a mere will. Indeed, an inheritance contract can set out any obligations for the beneficiaries, even quite formal ones, or no obligations at all. In such a case, the estate will pass to beneficiaries immediately and not within 6 months' time. My third point, and another disputable issue, concerns the parties to the inheritance contract. Obviously, one of the parties is the testator, an individual or spouses. Another party can be a person with a statutory right to inherit, so legal heir. According to the Russian Civil Code, those persons include individuals and legal entities, as well as the states. I mean, I'm now just enumerating persons who are capable, who are entitled to inherit. So individuals, legal entities, as well as state, municipal entities, foreign states, and international organizations. Indeed, all of those entities can potentially be beneficiaries under a will. However, it is different with an inheritance contract because the parties are supposed to conclude it, to conclude the contract. Therefore, it's, well, theoretically, it might be feasible. Well, certainly. However, the relevant regulations are lacking. So we don't have the relevant regulations. So this can exist only, well, theoretically. Another important issue is that the testator can freely dispose of the property that constitutes the subject matter of the inheritance contract without notifying the other party of the inheritance contract. And this approach can potentially, if we think about it, can potentially lead to deceit on behalf of the testator. However, if the beneficiary learns about such a fact during the testator's lifetime, he can claim damages and the termination of the contract in court. And in order to avoid disputes, legislator could provide or might provide rules limiting the testator's right to dispose of the property, which is the subject matter of the inheritance contract, well, at least to a certain extent. For instance, the legislation in Latvia, Latvian Civil Law Act, contains a provision according to which the testator can dispose of the subject matter of the inheritance contract only in, and this is a quote, reasonable quantities. Therefore, the contractual heir in this situation, in these circumstances, contractual heir is more protected. Similarly, the Civil Code of Ukraine provides that apart from the certification of the inheritance contract by a notary, the notary imposes a restraint on alienation of the contractual property by the transfer, that is by the testator. Therefore, the property subject to transfer upon the testator's death or upon the transfer's death should be specified in the inheritance contract. The testator cannot use the language specific to wills and state that in the inheritance contract that they intend to transfer, and I am also now going to quote the provision, all the property of whatever kind and wherever located to the specific person. So the transfer remains in possession of their property, but they do not have the right to dispose of that property. Well, obviously, the Russian legislation has followed the German model of the inheritance contract. However, in this case, it would be reasonable to set out a similar rule stating that if the testator has made a gift with the intention of adversely affecting the contractual heir, the contractual heir may demand the return of the gift from the recipient, thus providing a minimal protection for the beneficiary. A joint will is another mechanism implemented by the law of 2019. In this case, Russia has also, to a certain extent, followed the pattern of German legislation, German approach. Therefore, a joint will can be drawn only by persons who are officially married. Before the adoption of the joint will, the deceased spouse's share in the property became part of the estate and was subject to inheritance. However, from the 1st June 2019, a joint will can envisage the transfer of the joint property to the surviving spouse and thus avoid splitting of assets, particularly splitting of business assets. Dissolution of a marriage or its recognition as invalid, both before and after the death of one of the spouses, entails the invalidity of the joint will. And it seems that the mandatory provision concerning the loss of validity of a joint will in the event of marriage being declared invalid after the death of one of the spouses violates the rights of a bona fide spouse. It might be useful to modify the civil legislation with provisions that would grant permission to the court to keep such a will in force in order to comply with the legitimate interests of the bona fide spouse. A joint will may be revoked after the death of one of the spouses, and this provision in certain way, well, at least it seems that this provision in certain way infringes the legitimate interests of that spouse's heirs. In this regard, it seems reasonable maybe to envisage a provision according to which a subsequent will revoking the joint will must not contain dispositions regarding the relevant property. Moreover, the Russian Civil Code does not allow to make or to effect to make a joint will in extraordinary circumstances. However, if allowed, that might be a good opportunity for the spouses in case of a life-threatening situation. Well, whatever it might be, we have already spoken about that. Russian law might follow the German approach, which contains such an arrangement and sets out a validity period of 3 months for such wills. Another issue deals with the reserved share, with the compulsory share. The law does not contain provisions setting out how to calculate it. Supposing one of the spouses dies, leaving forced heirs. However, under a joint will, estate will be subject to inheritance after the surviving spouse's death. Therefore, a question arises as to what to undertake in this situation. So yeah, what can be done in this situation? And the law is silent about that. So there are no provisions governing this issue. Another complicated issue is an obligation of the notary to notify one of the parties to a joint will about the fact of certification of a person's spouse's subsequent will. The matter is that the notary may not be aware of the existence of the joint will, as this information is only available either to notaries who certified the joint will or after the opening of inheritance. My next point is inheritance fund. This is another new mechanism and an alternative way to dispose of a person's property. Before its creation, there was no legal mechanism allowing to manage the deceased person's estate. Inheritance fund is aimed at persons with high income and a large number of assets. Since September 2018, Russian civil legislation has had this mechanism, a legal entity, that is inheritance fund, which is created upon the testator's death in accordance with the provisions of his will. And what I'm now going to say is important because I'm going to draw some conclusions. And well, it's found in documents upon the testator's death can be changed only by court order. According to the Civil Code, the testator cannot assess, so cannot check and cannot assess the efficiency and of this inheritance fund and make amendments to the founding documents of the inheritance fund as it is established upon his death. So he doesn't know how it is going to function, and therefore cannot check and cannot assess the way it functions. Therefore, the testator under these circumstances has to rely upon good faith of the notary and the executory body that establishes the fund and manages it. This might be, obviously, this might be a reason to refuse the idea of creating an inheritance fund, and Russian realities often might not be, let's say, encouraging enough for a person to leave his assets to third parties without any chances to control what's going on and how their assets are managed. Another issue is linked with a lack of mechanisms enabling to control the notary's activities. In this case, in case of an inheritance fund, beneficiaries are authorized to challenge the notary's actions regarding the establishment of the inheritance fund. However, only if his actions contradict the testator's intentions. No other ways are provided by the law. As for the notary's obligations to the beneficiary or beneficiaries in terms of the documentation to be provided, the only documentation, the only documents the notary must provide to the beneficiary is the founding documents and the decision regarding the establishment of the fund. Therefore, the notary does not provide periodic reports on the procedure, which can help beneficiaries check upon the timeliness and appropriateness of the notary's actions. Neither an executive body has an obligation to provide periodic reports on the fund's performance to the beneficiaries. The only option that beneficiaries have is to conduct an audit on their own expense. I'm sorry. At their own expense. Moreover, provisions regarding the inheritance fund do not touch upon the rights of the surviving spouse. The law is silent as to the marital property. Obviously, if the inheritance fund includes marital property, this might violate the rights of the surviving spouse. Therefore, if the surviving spouse is not intended to benefit from the inheritance fund, the law must, well, we might think that and draw such a conclusion that the law must set out the way to determine the share of the surviving spouse and its payment to him or her. This requires also amendments to the family code, which have not yet been made. The last thing that I would like to speak about today is the recent amendment to the Russian Civil Code. From the 1st of March 2022, Russian business owners are able to transfer business and personal assets worth at least 100 million rubles, which is now, I wanted to transfer and to say how much that would be in euro, but this is still unstable now to say so. And new private foundations Russian business owners have traditionally resorted to flexible foreign legal tools to for succession planning and asset protection purposes in civil law jurisdictions, in some common law countries. They have also used various international trusts, for instance, in Cyprus, Cayman Islands, and many other popular, well, and popular in this very sense jurisdictions. Different tools like life insurance and other instruments, although these are all well respected and reliable options. Many Russian business owners were hesitant to use them due to sometimes to complicated legal structure, sometimes due to higher costs and even language requirements. Such instruments also do not work well with purely domestic assets in Russia that require day-to-day management, such as Russian commercial organizations, as opposed to inheritance foundations, which I have already mentioned, and which, frankly speaking, have not caught on in Russia so far. Private foundations, well, due to the reasons and complications that I enumerated, private foundations can be established and tested during the lifetime of a person, of the founder of the private foundation. And this is the key difference between private foundations and the inheritance funds that I've mentioned earlier. In addition, they private foundations satisfy the need for a more flexible domestic instrument for transitioning a business to governance by professional management and for protecting the interests of heirs. The use of new private foundations can reduce the number of inheritance disputes in Russia over business assets and provide continuity and professional management for Russian businesses. It could also prevent the misuse of funds and ensure long-term financial support for family members. Private foundations are the Russian equivalent of the foundations established in civil law jurisdictions and can be used or might be used in place of foreign trusts. Russian and foreign assets with a value of, well, as I said, 100 million rubles and more can be transferred to a foundation that includes cash, investment portfolios, real estate, business assets, so shares and interests in commercial organizations and other property. And now I'm going to speak about a little bit about each of the points mentioned in the presentation that you can see. So the first is asset protection. The property transferred to a private foundation is not included in the estate of the founder. So it doesn't constitute marital property and is not divided in case of divorce. For 3 years from the moment of establishment of a private foundation, the founder bears subsidiary liability for the financial obligations of the foundation, and the foundation for the obligations of the founder, so vice versa. However, the foundation is not responsible for the liabilities of the beneficiaries, and they are not liable for those of the foundation. Another point is management of the private foundation. Maximum flexibility is envisaged for structuring the management of the private foundation. The law does not establish requirements for managers, including licenses and other qualification requirements. And a foundation can be managed by, so therefore, as there are no strict requirements, foundation can be managed by any person. The management bodies can contain advisors, trusted advisors, and or legal entities of the founder, but not the founder himself and not the beneficiaries. The equivalent of a private trust company may be structured in Russia or abroad for purposes of managing of private foundations. So that might be a possibility. Another aspect is some interests of the founder and control. So the founder can be included in the supervisory board of the foundation, and his or her approval can be required for the transactions defined by the founder himself in the charter documents of the foundation. The founder can also change the charter terms and, well, other documents regarding the private foundation during his lifetime or her lifetime and adjust them. And this is, well, another difference from the inheritance fund and another advantage of this private foundation. For additional control, it is possible to create an oversight body, the equivalent of a protector in a trust. Another point, beneficiaries. The beneficiaries of a foundation can be members of a family or any other group of persons, except for commercial organizations. Such persons may receive regular or single distributions on the occurrence of the conditions set by the founder, but cannot participate in the management of the business transferred into the private foundation. The beneficiaries have the right to demand information on the activity of the private foundation in the cases set out in the charter of the private foundation, and also the right to demand the audit of the foundation. Another difference from inheritance fund. Foundations, however, are not subject to mandatory audits. The founder can also be a beneficiary and receive regular payments during his lifetime from the foundation he has established. This is also something different. As for taxation, so far, there have been no special tax and currency control benefits that have been introduced for the new private foundations. A foundation will pay corporate profits tax and be a tax agent for individual tax purposes. As for payments to the beneficiaries, they are subject to individual income tax withholding, which, well, is at the rate of 13 to 15% for residents and 30% for non-residents. And the beneficiaries will not have to submit tax returns and pay tax on the payments from the foundation on their own. As for the prospects, and this is my last point regarding private foundations, the prospects, I think there are, well, actually, we might speak about the advantages of those private foundations, and the main and one of the important advantages of the private foundations is that this new mechanism can reduce the number of inheritance disputes in Russia over business assets, and as I have already mentioned, might provide continuity in business and continuity in professional management for Russian business. It could also prevent the misuse of funds, and also they can ensure long-term financial support and stability for family members. However, for private foundations to become a popular wealth management and succession planning tool for, well, let's say, wealthy individuals in Russia, it is necessary to fix some of the initial drawbacks of the legal and tax regime applicable to those new private foundations, as well as to develop Russian law, Russian legislation, and, well, develop reliable court practice on the protection of assets. This is all I wanted to say about the current developments in Russian inheritance law, and the conclusion that we might draw here, as well as the conclusions that were made in my lecture dealing with family law matters. Also here, we might suggest that Russian inheritance law is relatively young compared to many foreign jurisdictions, as it has begun to develop properly since 2001, since the adoption of a new civil code, because as we have already seen today, the history of Russian succession law before adoption of the civil code of 2001 was some periods was very turbulent due to some historical and political, social, and economic circumstances. In some periods, it was it stagnated due to the fact that many people just had nothing to transfer, nothing to pass through using those inheritance succession regulations. And this is why many mechanisms which are present in many foreign regulations, which have been present in foreign jurisdictions for many years, are completely new for Russian law. And in some matters, there are, certain, let's say, still loopholes in the legislation. And in some matters, as I have mentioned, even the court practice is lacking. So, we are definitely not at the very initial stage of the development of succession law, but we are still trying to develop and to adjust certain provisions. And we need some more years in order to make all of those new mechanisms introduced into Russian legislation governing succession issues to work those mechanisms more effectively, and for them to become a more efficient and effective tool to distribute property. So this is all I wanted to say, and thank you for listening.
Molte grazie per questa ricchissima illustrazione del sistema ereditario russo a partire dalla rivoluzione fino ad oggi. È giusto, condivido assolutamente quello che lei diceva alla fine. L'evoluzione è legata, lo dico in italiano forse più semplicemente, è legata all'aumento della ricchezza individuale. Più aumenta la ricchezza, più cambia il sistema ereditario. Il nostro, osservava lei, è abbastanza stabile. Quello russo nel tempo è cambiato tanto. E il nostro è più stabile perché la nostra codificazione da dove viene ancora oggi il codice del 42, viene dal codice del 65, il codice del 65, del 42 viene dal codice del 65, il codice del 65 viene dai codici preunitari e poi c'è il codice Napoleone dietro. La storia del nostro sistema ereditario è la storia del trasferimento della proprietà, prima la proprietà terriera, poi la proprietà industriale, i crediti. Diciamo la storia del nostro sistema delle successioni è legata più al cambiamento di quello che si trasmette piuttosto che al volume della ricchezza da trasmettere. Cambia l'oggetto della trasmissione. Con l'evoluzione industriale, con la rivoluzione industriale cambia con l'economia moderna, tutte le questioni che sono relative ai trust, ai fondi e tutte queste cose sono venute con l'economia industriale evoluta. In Russia sono arrivate dopo, ma è un'evoluzione naturale, aumenta la ricchezza, cambia il sistema di trasmissione. Sotto un altro profilo il sistema russo era molto più avanti fin dalla rivoluzione nel parificare uomini e donne. Questo da noi è arrivato molto più tardi, ma questa idea di parificazione, di tutela, questa era già presente, non lo sapevo, è singolare, è molto interessante che all'epoca della rivoluzione nel 1917 già ci fosse questa idea di parificazione totale. Vabbè, non starmi comunque a fare la discussione, stavo portando via il lavoro alla professoressa, alla quale cedo senz'altro la parola.
Grazie molte. E anche io mi associo chiaramente ai ringraziamenti per la professoressa Buniatova per questa così interessante relazione sul diritto delle successioni russo, veramente densa di contenuti. E ci tengo anche sinceramente a ringraziare, anche a nome dell'Osservatorio su persone e famiglia del Centro di Studi Giuridici dell'Università di Roma Tor Vergata, gli organizzatori tutti per questo più che gradito invito a partecipare. Grazie al professor Zaccaria, grazie al professor Pescaro. Si tratta, lo dico sinceramente, di un'occasione di dialogo scientifico davvero interessante. La panoramica che la professoressa ci ha presentato, lo abbiamo ascoltato, è veramente ricca di spunti di riflessione, va dal diritto delle successioni appunto di epoca sovietica a quello della Federazione Russa, sino alle più recenti riforme del diritto successorio. Io ci tengo a dire subito come agli occhi del romanista, dello storico del diritto, quanto sin qui è stato detto susciti più di una suggestione. Ma d'altro canto la declinazione orientale del sistema giuridico romano non è una cosa nuova, illustri studiosi prima di me l'hanno, e meglio sicuramente di quanto io possa fare, l'hanno evidenziata. Mi limito a richiamare tutto il filone di studi e di seminari su Mosca, Terza Roma. E mentre la professoressa parlava, a me veniva in mente anche un bellissimo scritto di un grande romanista e politico italiano, Giorgio La Pira. Lo scritto è del 1922 dal titolo Mosca e Roma, nel quale Giorgio La Pira, anche in critica agli eventi di quel periodo storico, sottolineava proprio questa unità tra Mosca e Roma nel segno dell'unità del sistema giuridico romano. E questo, apro e chiudo parentesi, mi verrebbe da dire, a testimonianza di quanto poi il dialogo scientifico, no, possa servire anche, non voglio dire come strumento di pace, ma sicuramente come importante strumento di vicinanza fra i popoli. Io solo alcune brevi riflessioni, visto appunto che gli spunti sono tantissimi. Sul decreto dell'abolizione dell'eredità del 1918, a me viene in mente a tal proposito proprio la riflessione di Karl Marx. Già Marx aveva, no, evidenziato come il modello, così come il modello della proprietà individuale, anche quello della successione mortis causa rientrasse negli schemi giuridici in qualche modo funzionali non solo alla conservazione, ma anche all'accrescimento della proprietà privata della borghesia. Tuttavia però, diciamo, lo stesso Marx aveva già affiancato nella sua riflessione un primo momento di critica più dura, che poi era sfociato addirittura nella proposta, no, di abolizione nel manifesto del Partito Comunista del diritto ereditario, ad un momento di parziale recupero successivo di circa 20 anni, successivo nel quale riconosceva come il diritto ereditario non sia la causa, diciamo, quanto piuttosto l'effetto, no, del capitalismo basato sulla proprietà privata. E quindi, diciamo, nella riflessione di Marx, annientata o arginata in qualche modo la seconda, il primo poteva essere conservato, anche se limitatamente ai beni personali, non a quelli produttivi. E questo a me viene da pensare è una valorizzazione in qualche modo, insomma una forma di valorizzazione in qualche modo di quegli aspetti poi non patrimoniali dell'eredità che noi nei nostri codici, nel nostro diritto successorio abbiamo quasi totalmente perso, ma che rappresenta anche un gancio molto interessante con l'esperienza giuridica romana, per esempio. Altro punto, la distinzione, l'utilizzo delle categorie successore ed erede. Ecco, l'utilizzo di queste due categorie, lungi dall'essere scontato, io a titolo solo meramente semplificativo ricordo che il recentissimo Codice Civile della Repubblica Popolare Cinese del 2021 non distingue tra queste due categorie giuridiche, così come la precedente legge sulle successioni cinese dell'85 non faceva, non distingueva, ma si tratta di categorie che rappresentano un fossile romanistico che è declinato poi, l'abbiamo ascoltato, nell'esperienza giuridica russa. Ecco, i codici civili, noi lo sappiamo, accolgono spesso un patrimonio di origine romanistica che, nonostante poi la complessità della vicenda storica che li ha caratterizzati, dal diritto arcaico fino alla compilazione di Giustiniano, il Corpus Juris Civilis, con tutte poi le declinazioni successive, altrettanto spesso però dimostra una straordinaria capacità non solo di resistenza, ma anche di adattamento ai nuovi problemi giuridici delle società delle quali quei codici poi sono diretta espressione. E ecco, queste due categorie sicuramente rappresentano in questo senso un esempio di ciò, quindi successore con la declinazione di successione, erede di eredità. Schematizzando e cercando di sintetizzare al massimo per ovvi motivi di tempo, erede esprime sin dalla realtà giuridica arcaica romana un nucleo primigenio. La dottrina ha parlato di categoria presuccessoria perché si è eredi, non si diventa eredi. Tanto è vero che probabilmente lo ricorderete, in diritto romano il paterfamilias poteva indicare nel testamento un altro erede, ma doveva prima estirpare con l'ex heredatio la qualifica di erede al filius o alla figlia in potestà. Diversamente invece successore, successione emergono, sono categorie che emergono sempre nella realtà giuridica romana, ma sono nozioni diciamo più mature, oltre che più raffinate, anche se non andiamo oltre il primo secolo d.C. E nel verbo latino succedere, no, l'idea, l'immagine giuridica evidentemente sottesa è quella del subentrare nell'universo giuridico del decudius, mentre diversamente per l'erede l'immagine, diciamo, più acconcia potrebbe essere quella della continuazione. Ecco, queste sono categorie che poi noi troviamo, lo sappiamo, diversamente declinate nei nostri codici civili. A me ha colpito il richiamo che qui se ne è fatto. Ultimo punto, e mi avvio alla conclusione. Sulla seconda parte dell'esposizione della professoressa, il richiamo al dato per cui nel codice civile del 2001, che l'abbiamo sentito, ha seguito poi il percorso delle legislazioni dell'Europa occidentale, Germania, Francia in particolare. Da un lato si privilegia in qualche modo la successione testamentaria, quella legittima. La professoressa ricordava l'introduzione di tutte le tipologie di testamento. Dall'altro però contestualmente viene ampliata la cerchia degli eredi cosiddetti legittimi. Ecco, queste osservazioni a me fanno venire in mente la dialettica di per sé inconciliabile, ma questo sin dall'antichità, tra i due modelli della successione testamentaria da un lato e quella legittima dall'altra, che sono rappresentativi sin dalla loro immersione nella realtà giuridica romana e poi nella tradizione anche civilistica che li ha diversamente declinati, di una corrispondente antitesi inconciliabile proprio nell'individuazione del proprio successore universale a causa di morte. Se infatti il primo modello è quello della successione testamentaria, è emblema, espressione privilegiata della forza della volontà della persona umana di scegliere il proprio erede, il secondo modello, quello della successione legittima, stabilisce a sua volta un ordine, lo sappiamo, inderogabile di successibili, che privilegia evidentemente un'altra logica, che è quella della resistenza nella continuità del gruppo familiare. Questa complessità di regime, dicevo, diversamente declinata poi nella tradizione civilistica fondata sul diritto romano, di cui il diritto russo a pieno titolo, per quanto mi riguarda, fa parte, rappresenta una costante nei nostri codici civili. Tanto è vero che negli stessi, noi lo sappiamo, si tende a sancire, diciamo, di regola la preeminenza della successione testamentaria, proprio in quanto diretta espressione della volontà del singolo, la studi direbbe della supremazia della volontà del singolo, volontà di cui peraltro il testamento è espressione evidentemente privilegiata. soprattutto nella sua rilettura pandettistica, non esclusivamente, non solo di atto mortis causa, ma di negozio giuridico unilaterale mortis causa. E dall'altro poi parallelamente però si inseriscono costantemente correttivi a questo, poi con quote, lo abbiamo sentito, che possono essere più o meno variabili, a favore di quelle categorie di soggetti che sono legate al de cuius e che ogni ordinamento ritiene non possano essere escluse dalla cosiddetta vicenda dell'eredità, in termini appunto di successione necessaria. D'altronde, concludo, certo questo non può stupire se si considera da un lato in via prodromica come il contenuto, appunto lo dicevo all'inizio, non patrimoniale dell'eredità, poi non trovi, ma questo già dal diritto privato del secondo Ottocento, una vera e propria rilevanza, in quanto ad essere valorizzato e poi prevalentemente quello, l'aspetto patrimoniale, ma anche come i confini più o meno ampi riconosciuti al principio dell'autonomia testamentaria, quale diretta proiezione dell'autonomia privata, siano nei diversi ordinamenti giuridici la diretta espressione di scelte di politica del diritto direttamente funzionali alle società di cui sono anche rappresentazione. Grazie.
Abbiamo superato l'ora imposta, professor Tescaro, dica lei.
Avremo ancora 4 minuti.
In 4 minuti. Fine la conclusione delle conclusioni.
Se davvero devo o posso dire qualche parola, io sono rimasto molto colpito dalla relazione della professoressa Buniatova e in realtà poi anche dal commento che doveva essere finale della professoressa Marini, quindi non volevo sostituirmi a lei. Ho preso molti appunti e mi ha colpito, è già stato sottolineato dalla professoressa Marini, però il ruolo crescente che è stato assegnato al testamento nella evoluzione del diritto russo, con la precisazione, se ho ben capito, che rimane comunque poi poco utilizzato nella prassi, salvo forse il periodo pandemico per ragioni contingenti. Allora è stato presentato il testamento come lo strumento che caratterizza una società moderna, economicamente sviluppata. Però mi chiedo se questo non sia in realtà più qualcosa di apparente, perché poi forse anche nella società italiana non ho statistiche precise, ma credo che la maggior parte delle successioni sia in realtà intestata. E poi, sempre riguardo alla successione testamentaria, se ho ben capito c'è un ruolo molto forte del notaio in Russia. E questo da noi, anche qui non ho statistiche precise, però senza nulla togliere l'importanza del notaio, ho l'impressione che siano meno i testamenti notarili rispetto a quelli olografi. Non so se il professor Zaccaria, ecco. E quindi non capisco se c'è una maggiore fiducia nel notaio in Russia o se forse questa fiducia è un po' imposta o comunque diciamo sollecitata dal legislatore che non prevede altri strumenti rispetto al testamento notarile. E mi ha colpito molto anche un'altra linea evolutiva, quella di un ruolo crescente per l'autonomia privata, non solo testamentaria, quindi giungendo anche a recepire quello che è il modello tedesco. Si è parlato di un recepimento di questo con allora i patti successori e il testamento congiuntivo. Volevo solo segnalare che questa è una linea evolutiva non necessitata qualora ci si voglia rivolgere in una direzione appunto di una società europea continentale, perché per esempio il modello italiano è diverso. Noi manteniamo un divieto tendenzialmente rigido dei patti successori, divieto del testamento congiuntivo, e abbiamo introdotto un istituto particolare che è il patto di famiglia concernente le aziende e le partecipazioni societarie, quindi c'è un'apertura però specifica diciamo per i rapporti di impresa. E, nonostante che si discuta molto in Italia sul superamento di questo assetto verso la direzione tedesca, non sono sicuro che il nostro sistema non possa continuare a funzionare in questo modo, anche nel rispetto della tradizione romanistica, dove il divieto dei parti successori era fermo. E poi mi ha colpito un ultimo punto, che è quello, diciamo, del trust o di istituti analoghi, e se ho ben capito, ma chiedo conferma, mi pare che quindi la Russia sia arrivata ad introdurre in tempi molto recenti una disciplina interna di qualcosa di simile al trust, però un istituto russo, autonomo russo, regolato nel dettaglio, e questo mi pare un approccio molto apprezzabile che anche il legislatore italiano dovrebbe seguire, cioè di introdurre una legislazione interna piuttosto che, anche per scopi di certezza del diritto, piuttosto che ricorrere a istituti come cosiddetto nostro trust interno, cioè un trust regolato da una legge straniera però per un rapporto puramente interno italiano. Noi siamo arrivati a riconoscere questo nella nostra giurisprudenza, però è molto discutibile. Ma non mi dilungo oltre, volevo ringraziare però sentitamente di nuovo la professoressa Buniatova per la sua presenza qui e per la relazione.
Con ciò consideriamo concluso l'incontro, e lei è il padrone di casa, quindi lo deve dire lei.
Allora, grazie ancora anche alla professoressa Marina e al professor Zaccaria, e l'incontro è concluso.